Hey, I'm Mark Stevens, author of Government Indicted, the website markstevens.net. Got to do a little more on Dale's ticket getting thrown out because there's some important issues here that I want to bring out that I didn't get into him with on the other video from the radio show on Saturday, the No State Project. Which big congratulations again to Dale for getting that tossed out and for providing me the documentary proof. So I know there's going to be a lot of there's going to be some of the typical critics. They know who they are. There's 3 or 4 of them that go 24 hours a day on, it seems, on my YouTube channel saying the stupidest things. So I want to address some of that, but I also am doing this so that other people who may see what's going on, they have some information that they can, more information that they can make a better informed decision if they are going to defend themselves in this manner. Real briefly, the judge had pretty much asked the prosecution if they had read the discovery request and the motion to dismiss. They claimed that they had skimmed over it. The judge says, I would advise you to read over it carefully, and had asked the prosecution if they had the evidence that was being requested in the discovery request. They claimed that they needed 30 more days to give them this because this was given to them weeks in advance. They had not been able to produce the evidence. So at the end, before the 30 days was over, the prosecution put in the motion to dismiss, which the judge granted. So typical criticism is that not that it's necessary to prove that my position is true, that there's no evidence proving the Constitution code applied, because that's easy to do. They're just men and women forcing us to pay them. Forcing people to pay you doesn't create obligations of allegiance and protection. Maybe to the clinically insane, or, well, status apologists, maybe, but that doesn't make it true. So we are always challenging the prosecution's assertion that just because you're physically in Indiana, that the constitutional laws apply. That is the basis of jurisdiction, whether it be personal, territorial, or subject matter jurisdiction. Because an element of the crime is the code itself. Because without that, there is no wrongdoing. So I want to go through, because you have to see a lot of what is in the discovery/Brady request to really get the impact of this dismissal. Yeah, and I know, like I put in the article, I'm going to just type it was a traffic ticket, whatever. See, the claim is that no judge in any court has seen any merit whatsoever in my position, ever. This is proof that they are dead wrong once again. So the things that we're asking for are the names of every witness the prosecution relies on to prove that the alleged defendant was present within the plaintiff's state of Indiana. That the witness the prosecution relies on that the Constitution and laws of the plaintiff's state apply to the alleged defendant just because they're physically in Indiana. And evidence of a valid cause of action, which their cause of action is you violated the law. And they have to have proof that that is true. That's part of the cause of action. It's an element of the charge that has to be proven beyond a reasonable doubt. You don't do that with legal citations. Well, they do, not technically, but they get away with doing it every day. So that's a big one. Those are the big ones. We also want, of course, the evidence known to the complaining agent at the time that the defendant was present within the alleged plaintiff, being the plaintiff being the state of Indiana. So I want to go down here. Any evidence that the alleged defendant is subject to the Constitution and laws of the plaintiff's state just because the defendant is physically in Indiana. That's a big one. These are pretty big. And then number 7 is the names of any other witnesses with personal first-hand knowledge the prosecution relies on to support any element of the alleged crime. And the big one is, if you're physically in Indiana, our laws apply to you. That's the biggest one. That forms the foundation. So there's also evidence to prove the witness relied on has personal information. So if you see Rule 602, there has to be evidence introduced to show that the witness has personal knowledge of the matter that they are testifying to. So those are the big ones. So there's not much to this. It's only 2 pages long. There's only 11 parts to it. And so the rest of it we get into witnesses, names of any witnesses relied on by the prosecution that have been dishonest. That's part of the Brady material. any material that's used to impeach the prosecution's witnesses. So now, if the witness doesn't have personal first-hand knowledge, the prosecutor has to know that. And if the prosecutor knows that the witness doesn't have personal first-hand knowledge, that's Brady material, because that could be used to show that the witness is incompetent. So they have to disclose that. They have to say, hey, this police officer actually doesn't have personal first-hand knowledge of this. But the judge is not going to hold me accountable to that. So at least let them argue that. So going through this, now it's very common for discovery material, discovery requests, to have some parts that are relevant and some parts that are not relevant. So the big question I have for critics here is, if asking for evidence proving that the Constitution and laws apply because you're physically in Indiana, if that is truly frivolous and is not valid, relevant discovery material, why the hell did the judge, who obviously read it and insisted that, or suggested strongly that the prosecutor read that, why would the judge not strike that part from the request to tell the prosecution that they didn't have to respond to that? Why? That's a big damn question that they can't answer. That's a pretty big question. There was no point that the judge ever ruled that any of the 11 issues, questions raised, or discovery raised in there, none of it. He never said that any of them were irrelevant and not proper discovery material. Okay? So we could say, well, the judge is a busy guy, very smart. He's been doing this a long time. He just got elected again. Obviously, he's a competent individual. But could he have overlooked the parts of some of the discovery? I don't think so, because he was insisting that the prosecution really read through it. So I don't think he's overlooking the fundamental parts of it, the most important parts. So I don't think so. It's possible he overlooked it, but I don't think it's too probable here, given what Dale testified to on the show, that the judge was saying, you better read through this carefully. So I don't think so. The other part of this is, too, the other Juris Doctorate, the prosecutor. The prosecutor, could have just followed the sage advice of some of these critics on my YouTube channel, why wouldn't the prosecutor just say, objection, I don't need evidence to prove the Constitution and Code apply. This is not discoverable material. I object to number 9, or I object to this and that. Did the prosecution object? No, they didn't object. So why aren't the prosecutor and the judge like these unbelievably smart critics of mine? Why didn't they just claim this is not discoverable material? I don't have to prove that. I don't need a witness with personal first-hand knowledge the Constitution applies. I don't have to prove that. So you have two individuals who are very experienced. One just got elected a 7th time, either a 6th or 7th time, to the position of judge. Both of them not objecting to whether it is proper discovery material. Now the critics, of course, oh, that's ridiculous. It's completely insane what Marc's doing. He's an idiot. It's not discoverable material because it's a pure issue of law. Well, Scott Bales of the Supreme Court in Arizona disagrees with that. He agrees it is an issue of law because he's not an idiot, and he didn't provide any evidence, but he certainly didn't try to make a case that the applicability of the Constitution is a strict issue of law requiring no evidence, because only an idiot would think that the practical application of a law requires no evidence. See, smart people, people who are logical and do some research, understand the difference between theoretical and practical. So again, why didn't the prosecution at any time in those 30 days object to the discovery material or the discovery request that were not proper? Because they are. You have to get it through your head that when a police officer or any bureaucrat, when you say the Constitution applies to Mr. X because they're physically in Indiana, that requires evidence. It's an element of the charge, for heaven's sakes. So even though this is very short and only has 11 sub-elements of what we're asking for, not one objection. So you could argue, oh, the prosecutor isn't as smart as the YouTube commenters. Oh, yeah. The YouTube commenters are so smart that 2 Juris Doctorates with decades of experience couldn't catch something so glaringly frivolous. Yeah, right. No. If it truly was frivolous, if it really was not a legitimate issue of discovery, the judge would not have ordered the prosecutor to provide it, and the prosecutor wouldn't have felt the damn need to lie to the judge's face, claiming they needed 30 days to come up with that evidence. 30 days. Evidence they were supposed to already have in the file. So, I just want to address this also. I don't believe that these are thrown out because they're too much trouble. Oh, we're porcupines! No! Traffic court is a joke. And anyone who's been to traffic court knows that the prosecutor is getting an easy conviction a lot of the time. If not most. Not most of the time with us, but most of the time with, in general. Because this is a very short list of what the prosecutors get away with. Okay, tell me, this is not a difficult conviction. This is not too much trouble to get a conviction. The prosecutor has their burden covered by the judge. Oh, he doesn't have to have proof. They allow him to argue without evidence. The judges don't presume innocence. They presume that the code does apply to you with no evidence whatsoever. They also hold the prosecutor's position as absolutely irrefutable. How much trouble can it really be to argue and win a conviction when your foundational claim is irrefutable? No, it's not too much trouble. They impeach the police officers and still take the testimony anyway. Wow, that's an easy conviction. They deny cross-examination routinely, won't allow you to put on a defense most of the time when they do that. Imagine that, a conviction where the defendant doesn't get to put on a case. And last but certainly not least, they threaten the defendant with a psychological evaluation just for questioning your claim. Imagine how easy it is to go in and get a conviction when the judge, in some cases, will actually threaten contempt or a psychological evaluation because the defendant had the temerity to actually question one of your legal conclusions, one you're supposed to prove beyond a reasonable doubt. So I don't get this crap that it's too much trouble, we're porcupines. No, traffic court is a friggin' joke. The rules simply do not apply. The prosecution can argue without evidence, but you try to do that. You don't get to do that because there's 2 sets of rules. And the prosecutor has gotten many free passes. So I don't believe any of that crap. So keep that in mind about this, why I think this is so significant. So the idea that no judge in any court has ever seen the merit and admitted that there was merit to my position that there's no evidence the laws apply, and there has to be evidence that the laws apply, this now stands as more evidence against you. Because if the judge did not see the merit, he would have not ordered the prosecution to have to respond, and the prosecution would have brought it to his attention saying this is not discoverable material, and the judge going, oh, didn't happen because the judge did see the merit. And it's not even necessary. All you have to do is understand the basic principles of logic. No, you don't need to have someone agree with you, let alone a judge, a so-called authority figure, to determine whether your position has merit. The underlying evidence and the logic that led to your conclusion, that is what determines whether it's valid. Well, not just because some man wearing a black dress thinks so. No, that's just an appeal to authority. So that's the takeaway from this. A judge did accept the merit even though it's not necessary, and it just shows that all the critics that are saying a judge has never seen the merit, again, that's not necessary, they have. So when you see the critics come in and say that's not what the judge did, ask for the evidence. Look for the evidence, because you're not going to find any more evidence than what I've presented here. And we've had Dale's own testimony to that effect. So, again, if there was proof, the prosecution would have presented it. They didn't. If it was not discoverable material, the judge would have stricken that part, and the prosecution would have objected to that. My name is Mark Stevens. This is another example of debunking prosecutorial crap and some of the stupid claims of the critics. If you disagree with anything I presented here in the video today, hey, markstevens.net, and I also do a live broadcast twice on Wednesdays and 3 hours on Saturdays. You're more than welcome to join me in real time on a live broadcast and set me straight. Show me where I got my analysis wrong. Show me where there's a gap or an error in the logic. I love to hear it. Again, my name is Marc Stevens. The website is markstevens.net.